Hi, everybody. I'm Jeff Weiss, co-chair of Steptoe's International Trade Policy Practice and lead of the firm's supply chain team. Welcome to Supply Chain University, where we dive into the legal, policy, and advocacy issues involving supply chains. To find out more, visit our website at steptoe.com. On this episode, we're talking about the U.S. Securities and Exchange Commission's proposed rule on climate-related disclosures and how the rule may impact supply chains. Our guests today are Scott Sinder and Ashelen Vicuña in Steptoe's Government Affairs and Public Policy Practice in Washington, D.C. Like me, Scott and Ashelen are core members of the firm's growing and interdisciplinary ESG practice. So Scott and Ashelen, thanks so much for joining us. We're really excited to have you here at Supply Chain University.
Thanks for having us.
It's great to be here, Jeff.
So just to kick things off, I was wondering whether you could provide us with an overview of the SEC's proposed rule on the enhancement and standardization of climate-related disclosures for investors.
Absolutely. So the rule is in the proposed stage. Comments were due 2 weeks ago. So the SEC is currently undertaking its review of those. But under the proposal, there's essentially three components to the rule. That would all add new reporting obligations on SEC registrants, so publicly traded companies. First piece is at some level, the biggest in terms of the amount of disclosure. It's a discursive description of a company's climate-related plans, transition plans, risk exposure, things like that. It's built on an existing framework that was issued by the Task Force on Climate-Related Financial Disclosures, TCFD. And it's meant to basically codify that framework as part of your 10K reporting obligations. The second piece is that to the extent you've identified anything in that TCFD framework that has an impact on any of your financial reporting, your line item reports, if it's more than a 1% change in any line item one way or the other, then you're required to note that in your financial statements. And finally, you also have to report on your actual emissions that you're making, and that now they use a different term in the proposed rule than supply chain. They call it value chain. So it's meant to include supply chains, but it's much more all encompassing because it includes all your partners kind of both above you and below you in your frame of work. So that's kind of the main components of the rule.
And how has the proposal been generally received thus far?
Controversially. I mean, I think that there's a lot of sentiment in support of doing something in the space and generally supportive of the SEC objectives here, particularly in the investment community. I think a lot of the details in the rules are very troublesome for some of the larger registrants for all sorts of reasons. And we'll talk about that a little bit in a minute, I think. But, I think litigation challenge to the rule when it's finalized is almost inevitable.
Right. I think to your point, let's discuss how the proposed rule might impact a service-heavy supply chain such as the hospitality industry, and then how that impact might compare to an investment-heavy industry such as commercial real estate finance. So focusing first on hospitality. What does a typical hotel supply chain look like?
Yeah, I can take that one. So, the hotel industry is really interesting just because of the broad nature of very service-heavy vendors that it relies on. It relies on an extensive network, likely globally. If it's a large company with properties all over the world, you're seeing a lot of local vendors and suppliers that are integral to the daily operations of the hotel. You have to think about your housekeeping staff, laundry services. If it's a larger hotel with a restaurant, your chefs and wait staff, also all of the inputs required to make a meal, all the sourcing of those ingredients. You might have an entertainment aspect. It's very service heavy industry. So to the extent that, hotels are reliant on a lot of different vendors. They can be local, small, private companies that hotels would need to then ask for these disclosures from, and we can get into that a bit more.
Yeah, I would add something here. In addition to that piece, the ownership structures are very different. So if you take some of the internationally branded chains, Marriott's, Hilton's, for example, even within a company, they have a number of different models. They may license their name for use on some properties, they own others, and then they may manage properties. Each of those scenarios creates a very different reporting regimen with respect to satisfying, particularly the emissions disclosures that we'll talk a little bit more about. And
Right.
so when you're just licensing your name, for example, you may have no ability to require the licensee to share the data that you'll need to make some of your disclosures that are required under the rule.
Right. And since you mentioned emissions, let's talk about that piece. I know that's the third major piece of the proposal. So maybe you could just provide a quick summary of the differences between the different emissions, scope 1, 2, and 3. And then in particular on scope 3, how would requiring collection of data on scope 3 emissions be particularly challenging for the hotel sector?
Sure. So the rule, like you mentioned, it relies on the GHG protocol, which is a widely recognized framework for how to divide up emissions into scopes. Scope 1 would constitute a company's direct emissions of things that it has ownership or control over. Scope 2 is indirect emissions from energy that it purchases. So electricity, heating, indirect emissions that are produced from that. And then scope 3 is really anything that's not scope 1 and scope 2 that's within, what we've been discussing, that value chain, those upstream and downstream parts of the value chain. In the rule and in the GHG protocol, they actually have a list of 15 categories of scope 3 emissions. It includes things like purchased goods and services, employee travel is one of them, and then particularly, as Scott mentioned, for the hotel industry, the franchise angle is something that hotels are really concerned about. Anything that your franchises are emitting would be considered part of the hotel's scope 3. So in terms of the hotel's major concerns, we would say that it's that scope 3 franchise angle. In addition to the goods and services that I mentioned with those vendors, you have also, smaller, likely private companies that are franchising a brand named hotel, for instance, and getting those emissions disclosures from that franchisee might prove difficult, particularly if already executed contracts that the hotel has with the franchisee might not include, these broad environmental disclosures, for instance, so that can prove challenging.
Yeah, the scope 3 reporting is definitely the most controversial component of the proposal. And one way to think about it is if you have two companies, one is a registrant. So let's say, Jeff, you're the registrant and Ashelen is your vendor. You're publicly traded. She's not, but she's an important piece of your value chain. All of her scope 1 and scope 2 emissions, so the direct emissions that she's making either from producing her own energy through her furnace, for example, or purchasing it, become your scope 3 emissions. And so that's really where I think you get a lot of the tension here is over that layered reporting and the ability of the registrants to even get at the data. Now, they do caveat that requirement. You only have to make those disclosures on scope 3 if one or two things are true. One is that it's material to you. That's a slippery concept. It's an old concept under the securities law, but it's not crystal clear. It's not black and white, what's material and what's not. The other is if you have a net zero or other environmental commitment to which these disclosures are important. I think one ramification of that is you're going to see a lot more scoping of corporate commitments so that they can be sure that they'll be able to do whatever scope 3 reporting is necessary under whatever commitment they've pronounced.
And I would imagine that since you're responsible for your everyone in your value chain, it's probably going to put more pressure to or make it more difficult to include small businesses in these value chains, since they may not have the level of sophistication of the larger companies in terms of measuring the emissions, right?
Yeah, I think that's fair to say. It's something we've been hearing, to the extent that a hotel or other businesses are relying on small businesses and would be requiring them to calculate and disclose those emissions, they might think twice and go to a more, a larger company that has the capability, the infrastructure, the personnel to produce that on a timely basis as well. We haven't really talked about timing yet, but that's a key piece of this too, is according to the schedule set out by the SEC rule, when you would need to disclose these emissions, it would need to be part of your 10K financial disclosure, which is typically within 60 to 90 days after your fiscal year. So, that timing is something that's incredibly concerning to a lot of companies who would need to gather all that data, particularly the fourth quarter data, and then vet it and produce it for this financial disclosure.
So do you all have any potential solutions for addressing this issue?
Yeah, I think one of the things you're seeing prevalently is just making Scope 3 voluntary, particularly given that the triggering of that requirement is based on materiality, but also if you've made any type of commitment. I think we've heard from a lot of companies that say that it could create a chilling effect on their, how forward-leaning they want to be on Scope 3. And so making that disclosure voluntary could, help with that and make sure that you're not seeing companies that want to just eliminate those net zero targets, those targets that would include their Scope 3 emissions. We're also seeing some proposals out there on just limiting the amount of the level of assurances that would be required to attach to these disclosures. Those are extremely costly, and companies that are already doing that have told us that the sort of limited assurances that they're already providing in other instances is pretty costly. This rule, starting in the fourth year of the cycle, would require companies for Scope 1 and Scope 2, not Scope 3, but for Scope 1 and Scope 2 to go up to reasonable assurances, which we've also heard is a very costly measure. So limiting those assurances and sort of reducing that liability exposure for companies, I think, are solutions that you're seeing.
So let's turn now to the commercial real estate finance sector. And can you describe any unique impacts of the proposal on lenders and other players in that space?
Yeah, and yes, I can. And what's interesting is it really is going to depend on where you sit. We do a lot of work with the commercial mortgage-backed securities industry. That right now is exempt from the disclosures. I'll come back to that. If you're a publicly traded lender, then you're going to have this issue. And a lot of life insurance companies are lenders, as are, of course, all the banks. But they're also, they're both publicly traded and not publicly traded. If you're publicly traded, it's going to be this question about whether the loans fall in with your Scope 3 reporting obligations. If you're not publicly traded, they obviously don't, because you have no reporting obligations. So you're setting up kind of a bifurcated world in the lending space. On the CMBS side, they have some trouble with the TCFD framework, with the idea that you would apply that to a bond issuance. So that question has been parked for now because the rule on its own terms does not apply to CMBS, not yet. But that'll be something that we focus on a lot going forward if the rule moves to be put into place.
And let's talk again about Scope 3 emissions with respect to this sector. How would requiring collection of Scope 3 emissions data be challenging for CRE finance?
Every borrower, at least somebody who's borrowed from anybody subject to the reporting regime, their emissions theoretically are part of the framework. And so typically you do 10-year loans in the space. So you have a loan or a lot of 10 years or less. But there are a lot of 10-year loans. You have a 10-year loan issued today. The borrowers have certain reporting obligations under those loan documents. They don't include the emissions reporting, the other climate-related issues. And so at least as a transitional measure, you have a lot of problems in collecting the data. More long-term, when CMBS is competing with some of that shadow banking industry, if they're required to collect the data and others are not, then you've got, again, the kind of unlevel playing field problem with access to capital.
And so how do you think the SEC could potentially address that problem?
I mean, that problem is really only addressed through exemptions. And it's a challenging problem for them to solve.
What do you think the timing is of the proposed rule at this point, and what can we expect in terms of moving forward next steps?
Well, as noted, the comments, the due date is passed. So the commission is actively considering the comments, and they're going to work on their final rule. I expect them to do it relatively quickly. I think that it'll be interesting to see the extent to which they make changes based on the input. A lot of times you don't see many changes from the proposed to the final rule. Here, I think they're going to be hard pressed to not at least address some of the problems that have been flagged. The bigger issue, though, and it's highlighted by the Supreme Court's decision today in the West Virginia versus EPA case. In that case, they just threw out the EPA's new requirements on tracking and doing certain activities for utilities emissions. They decided the case under something they're calling the major questions doctrine. I think it's the first majority opinion that's been issued in the Supreme Court where they've actually labeled it that way. But you can think of it as an exception to Chevron. The major questions doctrine, if the regulation is implicating a significant economic or political issue, then the authority to address it has to be clear. The congressional authority given to the regulator has to be clear. And so you see in that the framework for a challenge to the SEC rule. And I think that you're going to see a number of assertions that they don't have the general authority here, that their authority is really anchored in financial disclosures and nothing beyond that. Here, of course, you go well beyond that. Even some of the details, like the reasonable assurance that requires the audit. In the Sarbanes-Oxley, you have a similar parallel requirement, but that was effectuated by statute, not by rule. And so I think you're going to see lawsuits that will probably be filed the afternoon the rule is issued, if not the next day. And I think that those will take a while to resolve. I think the problem for the SEC is if it takes too long for that litigation, you may have an administration change before the court rules on anything with finality. In the next administration, and whoever they name as chair, they may have a different view of how these things should move. So we're a long way from done. I think it's going to be a process.
Right. Very interesting. Well, thanks so much, Scott and Ashelen, for coming on the show. Really appreciate it and hearing your insights on these issues. It's been really interesting to hear how the proposed rule potentially would impact different sectors, different value chains. It sounds like there are a number of outstanding issues that still need to be worked through. Whatever final rule the SEC ultimately issues will, as you noted, undoubtedly be challenged in court. Look forward to hearing how our work on these issues for our clients evolves as that debate moves forward, and hope that you'll keep us posted on where things are headed on this and other SEC-related climate measures.
Absolutely. Thanks for having us, Jeff.
Thanks, Jeff.
And also, please check out Steptoe's ESG webpage and also our biweekly newsletter for What It's Earth, where we cover the biggest ESG issues of the day. So that's it for this edition of Supply Chain University. You can find this and all of our videos at steptoe.com. And you can also find us on YouTube, where you can like and subscribe. Thanks, everyone, for joining us, and we'll see you next time.